Hi, good afternoon. Today is Thursday, July 21st. My name is Ashley Glover. I'm here with attorney Deanna Eble, and we are happy to welcome you to our webinar, Am I a Candidate for Medicaid Home Care? Thank you for joining us. Before we start, I do have a few quick housekeeping notes. Your mics are muted. You'll want to use the Q&A box to submit questions. We have reserved some time at the end to answer as many as we can. We are expecting a good number today, and we we only have one Deanna, so bear with us if we can't get to everything during this 30-minute session. We are recording, and we'll email a link to the video. Let us know how we did in the survey. If you need to message me about anything, please use the chat box. Okay, so let's get to know Deanna Eble, our presenter for this afternoon. Deanna is a partner at Russo Law Group. Her focus has been on elder law, estate planning, special needs planning, and Medicaid planning for 20 years. She really knows her way around the Medicaid rules and best practices, and she's currently appointed to the executive committee of the New York State Bar Elder Law and Special Needs section. Deanna, this is always such a hot topic. Everyone wants to know what's going on in the world of Medicaid. So here we go. Thank you for putting this presentation together, and I'm really glad you're here today.
Hot topic for a hot day, right? Hopefully everybody's inside in a cool space learning about Medicaid and how to qualify. And so, hold on, I just need to move our little heads. We're going to discuss today how to qualify for Medicaid home care, the Medicaid transfer penalty rules for home care, and how to protect your income with a pooled income trust when you're looking for Medicaid. So one of the things that we hear the most is, oh, I spoke to my neighbor. She said that I can't qualify for Medicaid, and so I'm going to privately pay for services. And hopefully our conversation today will get everybody to see that there are ways to manage your assets to qualify for the Medicaid benefits that are provided through the home care system. And the best thing to do is seek legal advice and not necessarily the comparison of what a friend or neighbor situation was, because you may not be comparing apples to apples and you may meet some qualifications or exceptions to the rule that they didn't. So it's always good to dive in and get it from a primary source than hear it from somebody in their experience. So without any further ado, I'm sure that many of you have been hearing down the pipeline in newspaper articles and just in general that there are changes that are coming for Medicaid home care. So the reason why I mention that is that there was a budget bill that was signed in April of 2020 that proposed changes for the Medicaid home care rules. Now, there are some things that are not changing. The things that are not changing are that Medicaid, the income allowance for Medicaid currently is $954 a month. You can also pay for supplemental insurance premiums. So supplemental insurance premiums are like your Medicare gap plans. So you have your Medicare as your primary. And then a lot of you pay for AARP, GHI, Blue Cross Blue Shield, those coverages that are there to pick up the 20% that you would have as a copay from Medicare. Those plans that pick up that 20% are also, the premiums are also allowed. So if you pay $300 a month for, let's say, AARP, you can have $954 plus the $300 that you would pay for that premium. That's pretty much what is allowable as far as monthly expenses are concerned. Now, don't say to yourself, oh no, I make more than that for an income, so I immediately don't qualify. The goal of this presentation is for you to understand that even with that prong being a little too high, there's still a way for you to qualify. So stick with us for this half hour and I'll explain to you how that happens. Understand also that this year, there was a law that was changed so that starting in January of next year, that $954 per month amount is actually going to be closer to about $1,400 or $1,500 because they're going to be using the poverty numbers. So that's a good thing, because a lot of people might just be over the number slightly, and now that they're increasing in January the amount that you're allowed for income, it will allow more people to be eligible for Medicaid benefits without added things that we're going to discuss as we move forward. You're allowed to have $16,800 of assets, and in that asset test, that $16,800 does not include something like a traditional IRA, because the IRA can be put into a payout status that would be under the income column, not the asset column. And there's some other nuances and exceptions to that $16,800. You can also own your house as long as the equity in your house doesn't exceed $955,000, then your house is an exempt asset. There's reasons why we would still transfer the house, but just so you know and understand, you don't have to transfer the house if its equity is below $955,000. Okay. Next slide. There we go. All right, so the tips and traps. So currently, under the current law, and the reason why we're presenting this as current law and new law is because, as I mentioned, back in April of 2020, a budget bill was signed to change the law to make it a little bit more difficult to qualify for home care services from Medicaid. Home care services are just that. It's Medicaid paying for somebody to come into your home and provide care for activities of daily living. So it's providing care for things like dressing, helping you bathe, helping you toilet, making sure that you're eating, whether it's feeding you or cooking for you, making sure that you're able to get up and walk from your bedroom to the living room, transferring from one place to the other. All of those types of things they consider activities of daily living. And you need to have, depending on which law we're under, anywhere from two or three of those activities, depending on whether or not you have any kind of diagnosis of dementia, that you require care or assistance with that. And so the current law as it stands, and the reason why I say current law is because even though the rules changed in 2020, we're still in a pandemic. And while the pandemic is out there and lurking, while the federal government feels that we're still in a state of an emergency, we cannot change in New York the rules to allow someone to qualify for benefits. So even though the law changed in 2020 on the books, we are still under this current way it was before the budget bill passed. That current way of doing things is there are no penalties for transfers. So what you hear sometimes out in the world is, oh, you can't give gifts, you can't do this, you're not going to be able to get Medicaid for that. There are two types of Medicaid that we generally talk about when we're talking about care. One is nursing home Medicaid, one is Medicaid in the home care setting. Nursing home Medicaid imposes penalties when you take money out of your name and gift it to your children or grandchildren. They look back 5 years. In the current home care setting, you can have money in your name today, give it to a family member before the end of the month, and in a technical world, you would be eligible to retroactively receive coverage from August 1st forward, because there are no transfer penalties right now for home care Medicaid. There's also not technically any look back for home care Medicaid. So when you talk in terms with a neighbor or a friend about the 5-year rule, that 5-year rule is a nursing home rule. That is not a home care rule. The home care world doesn't technically have a look back. However, many of us do provide 3 months worth of documentation with regard to financial information to the workers. And the reason why we do that is because Medicaid will retroactively cover benefits 3 months back from when you're eligible. So if you're eligible for benefits today, but you don't actually talk to someone or start filing an application until September, they can retroactively cover back to today, which means you could submit bills and ask permission to get reimbursed for those bills. Reimbursement is at Medicaid's rate, so you wouldn't get the full reimbursement if you get anything at all, but the benefit is there to at least try and get that kind of coverage. So we generally do give 3 months of documentation because of that retroactive coverage. We are certainly encouraging people to file if you need the care, if you need help with your activities of daily living, you're going to file before the rules change. Well, how are you going to know when the rules change? Certainly you keep in touch with us because we have a sense of that and we get informed of that. At the moment, the understanding is that while everything seems to be pushed to October 1st, it's in the community, in the elder law world, we are anticipating that at the moment, it won't be before January 1st of next year. And when all is said and done, and everybody has to be trained at Department of Social Services, it could even be that the rules are on the books changed back in up to January of next year, but they don't technically implement those changes for quite some time after because of the fact that they have to train their staff on how to properly process that kind of application. So if you need the care, now's the time to file for coverage, because we do still have this time frame in which we are waiting for the rules to change if they're going to change, and take advantage now. Okay. So let me just give you a scenario that will help you understand how all of this comes into play. We have Anna. She's widowed. She's 85 years old. She lives alone, and she's been recently diagnosed with mild to moderate dementia and has no long-term care insurance. She has 2 children, Barbara and Mary Beth. She owns her house in Nassau County that's roughly $500,000 of equity, and she has liquid assets of $250,000, but in that $250,000 of liquid, $100,000 of it is a traditional IRA. And I mentioned earlier that there's some exception to the IRA. She also has Social Security of $1,750 and a pension of $750. So under the current law, how would we do planning and get Anna on Medicaid, knowing that she has all these assets? Because you may say to yourself, oh, she doesn't qualify. Look, she's over the $16,800. So Ashley, if you want to give us the next slide. So under the current law, she can transfer her home to Barbara and Mary Beth. So you're going to say to yourself, but wait a minute, you said I could have $955,000 value of equity in my home. Why would I transfer it? The transfer is done because you can own a home and still qualify for Medicaid if you're below the equity threshold. However, Medicaid still has a right to put liens on the home. So if you own that home and then you pass, Medicaid could come back and say, wait, we paid out benefits for you. We want to get reimbursed for those benefits. And when the home gets sold, they can get reimbursed and put a lien on the property. To avoid that lien, we could transfer the home to Barbara and Mary Beth, because right now, as I explained, under the current law, there's no penalty to make the transfer to Mary Beth and Barbara in the home care setting. So we could take that house, transfer it to Barbara and Mary Beth so that it's no longer owned by Anna. And in doing that, we avoid the possibility of having liens. There's nuances on how we would do that transfer, but that transfer can happen. When it comes to the cash, we can't have more than $16,800 in Anna's name. So you can also transfer the cash to Barbara and Mary Beth. But you wouldn't transfer the IRA money. The IRA money, many of you have likely heard of required minimum distributions. A required minimum distribution is a calculation that the IRS requires for you to take money out of the IRA once you reach the age of 72, so that the taxes are being paid on that money. Because when the IRA was established, it was pre-tax money, and at some point the government wants to start collecting their tax money. So since 2019, the rule is age 72, you have to start taking your minimum distribution. Medicaid, while they don't make you spend down that asset, they maximize the distribution. So they use the Social Security tables to determine your life expectancy. And based on those tables, not the IRS tables, they then require you to take a distribution from your IRA that's a little bit higher than the IRS. If you change the distribution to meet what Social Security and Medicaid say, then the IRA is no longer counted as an asset. So Anna can have that $100,000 in her name. And the money coming out from the IRA is counted as part of Anna's income. We're not in the asset bracket with that IRA. So she's just moving the balance of the other $150,000. Okay. That is under the current rule. Like I said, we're not anticipating any major changes on that current rule, especially before January 1st of 2023. So if there's a need for the care, you could see from this example that now's the time to do that type of planning. You know, this is very generally how we make the transfers. I would certainly use trusts in this transfer because there's a lot of factors, but on a general sense, we want to be able to transfer the assets out of Anna's name to get her to qualify for Medicaid, because the goal is to qualify her for Medicaid. But what's coming down the pipe? What's going to happen if and when the changes occur? And I say if and when because at the end of the day, there's still a hope, you know, some of us elder law attorneys still have that hope that we may never get to the point that we're using these new rules, because at the end of the day, it doesn't always make sense, and it could hinder people from getting the services in their home and force people to be more in nursing home care based on how long it might take for them to qualify for services. So the new rules that are anticipated to be implemented in January are that there's going to be a 30-month look back. Not a 60-month like nursing home. They're talking 30-month, which is 2.5 years. That just means that when you apply for home care services, if this gets implemented, you have to produce financial documentation to show what kind of assets you owned over the last 30 months. And if you made gifts of your assets to non-exempt individuals, then the gifts would be subject to a penalty. Medicaid doesn't look to own your house or anything like that. They just say, because you had money and gave it away to someone who's not exempt, we are not going to pay for your care. You have to pay for your care. And here's the date that we will start paying for your care because, you know, to get past the penalty. That's really what they're saying. And some of those exceptions are transfers between spouses. And so we hear often that, you know, oh, I can't qualify, but you're married and transfers between spouses are exempt. So even in this 30-month look back, transfers between spouses are exempt. So the sick spouse can transfer to the well spouse, and then we can qualify for Medicaid. It's not that we wouldn't be eligible. The transfer is exempt. There's also exception in the transferring for individuals who are disabled. And there's ways, and depending on their relationship to the prospective Medicaid recipient, there are nuances in if they transfer to an individual who's disabled through either a trust or outright, depending on their relationship, they may also be exempt transfers. So you definitely want to talk to somebody to see what is available to you so that we can customize the plan to you and you know all of the things that are available and all of the pitfalls that you may be up against, if any at all. So the concern with the 30-month look back is that it will go retroactively back to October 1st of 2020 or 30 months, whichever is sooner. So if at some point when they finally decide to implement this change, if October 1st of 2020 is more than 30 months, they will only go back 30 months, but they will not go back any further than October 1st of 2020, okay? The look back period gets phased in. So if if they started that right now, then we wouldn't be 30 months in, we wouldn't have 30 months between now and October 1st of 2020. So we would only be going back to October 1st of 2020. Until April of 2023, you won't have a full 30 months in there. But like I said, this is not anticipated to even be a thought to start until January of next year. So we're just going to have the knowledge, know it exists, and not worry about it because we're still under the current rule, which doesn't impose any penalties. Because you need to also have proof that you need community-based care. You can't just apply and hope for the best. You want to make sure that you have the need for the care because there are some physical assessments that are done also. So transfer penalties for non-exempt asset transfers, what issues might come up? The start date we said is likely not going to be before January 1st, and I'm actually even hearing it's going to be later than that, but for ease of conversation, we'll say January 1st. The transfer penalty is going to start the month the Medicaid applicant, or I'm sorry, the penalty will start the month the Medicaid application was submit or when a request is made for an increase in coverage, which just means if somebody's currently on Medicaid and they're getting 8 hours a day and they feel they need 12 hours a day, if they're looking for an increase in coverage, then they have the right to start asking about penalties that were imposed. I'm not worried about that because many individuals have been on Medicaid for years. And so they've been below the threshold and their assets were transferred before October 1st of 2020. So I'm not concerned about that. And you shouldn't be concerned either. You just need to know that it exists. But the upside to all of this is at the moment when they do talk about transfer penalties and how it's going to work, they're using the nursing home rate. What does that mean to you? It means for Nassau and Suffolk County, roughly every $14,000 that you transfer, roughly, is 1 month that they're not going to cover home care. That's actually a good number because 14,000 is the nursing home number. We all know that home care in theory costs less than nursing homes. So if they're giving you credit for every 14,000 is only 1 month, it's almost like a 2-to-1 ratio that you're able to pay, you're able to get 2 months worth of monies out and only be penalized for 1. So it's not the worst thing in the world. So don't be intimidated by the changes. You just want to know that there's the possibility that this is lurking. And at some point, if you need the care, you want to definitely try and contact somebody to get the care sooner than later so you're not subject to any of this. But how does that work in our scenario? So if we go back to the scenario of Anna and how Anna had her assets and she needs to make her transfers, we want to know, well, in the big picture, you know, I threw a lot of numbers and information at you. How does it work in the real world? So under the new law, we would still make the make sure that the IRA is paying out monthly based on, next slide. We would still make sure that the IRA is making the distributions that we calculated in under the current law. But for gifting purposes, we can make the gift. We just also want to split your money into a gift and a loan so that we're making gifts. The gift creates a penalty. And then there's a loan that will be paying the applicant back on a monthly basis to cover the cost of care during the time the penalty is being imposed. Sounds complicated. That's why you're seeking legal advice. That's why you're part of this conversation. That's why you want to make sure that you get all the best information that's out there, because I don't want you to walk away. All of a sudden you hear on the news one day that the penalties are being imposed, and then you think that's it. I have to spend all of my money down. I want you to walk away from this discussion knowing there's always something that you can do. You should always make sure that you speak to legal counsel to make sure that you're getting the most pertinent advice to you and that you understand all of your options. So we were discussing a little earlier. Now we have Anna, who's got this income that we know is more than what Medicaid allows. We said she had $1,750 from Social Security. She had $750 from her from her pension, and there's also money that was coming from her IRA. Well, that clearly exceeded $954. What do you do? How can she still qualify for that? Well, understand that there are two options when your income exceeds the $954. The first option is to give it to Medicaid, and they will gladly accept it to pay down on your medical expenses before they kick in the first penny. But like you, I live on Long Island also, and there's no way that we're living on Long Island, putting a roof over our head, clothes on our back, and food on our table for $954 a month. So the option is to establish something called a pooled income trust. It is a trust that is established with not-for-profit, specifically approved in New York State. There's about 22 of them. And what can happen is the excess income that exceeds the $954 goes into this pooled income trust, and then you submit your bills to the pooled income trust company. So you get your cable bill, it's $200, you submit the bill to them, they pay the bill. Your electric bill, same thing. And you go down the list. Now, I've had many clients say, but I can't afford to pay all of my bills. The not-for-profit is not going to pay out more than you're paying in, but it's better to have the not-for-profit paying your bills than giving your money to Medicaid, and then you don't have that money to spend on your bills at all. So this is a great option to make sure that your income is still available to you. You're meeting the criteria of the $954 threshold that Medicaid set, and you're qualifying for benefits so that you can get home care services and stay where you want to stay. Next slide. So some of the tips and traps that we see is that individuals should implement Medicaid planning now if you're considering filing for Medicaid, because some people anticipate that they need the coverage, but then talk to too many people and feel that they don't, or that they're not going to qualify. And so rather than make the effort and see how they can qualify, they just don't apply. It's better if you need the coverage to apply now. Then wait, because like I said, there's an anticipated start date of January 1st of 23. Like I said, I do believe that that is even going to be pushed a little bit later, but at the same time, you don't want to be that person that gets caught up in things because you waited a little too long and now you're subject to rules that you could have filed a month earlier and been okay. You're certainly going to monitor the updates on the implementation of the new rule. And we are doing our part to make sure that you're aware of that and be an advocate for yourself and your family members. If you see somebody really could use the care, advocate for them and encourage them to seek the help. Okay, so Medicaid, how to become eligible in home care. The new law the change was supposed to take effect October 1st of 2020. That change was supposed to be a 2.5-year look back on documentation, and it was supposed to impose penalties. None of those things have happened yet, but they are still on the books. So don't be taken don't take for granted the fact that the law still exists. It just hasn't been implemented because of the pandemic, and there's always the hope that it will that it won't end up happening, but that doesn't mean that just because we're hoping for it doesn't mean it will happen. Any questions about the use of pooled trusts have certainly been answered by the Department of Social Services. So pooled trusts are still something that we can use. It's a great way to be eligible for Medicaid home care, still be able to use your income for your monthly expenses and get the services that you need. And you're definitely going to want to stay tuned so that you have a sense of how the law is changing, if it's going to change, and how we can help you and best understand that. Is a 403B treated like a traditional IRA? Yes, because a 403B is a pre-taxed asset. So a 403B, a 401k, all of those types of things are definitely treated the same way. How can I get a copy of meeting? So that's an Ashley question. I will let her mention that to you as she wraps things up. But what do you do now? So the best thing that you could do is meet with an attorney like myself so that you can create a plan. Make sure all of your legal documents are in place and comprehensive, because this plan is great, and knowing that you could do Medicaid planning and get the services is great. But at the end of the day, if you find yourself working with a family member who needs the care but doesn't have a power of attorney, and there's no way to transfer their assets, it gets more complicated, and it could create some delays in doing what needs to be done, and it could get more expensive. So you definitely want to plan in advance so that you know everything's comprehensive and done, and then you want to implement the plan. So as soon as you're told what steps to take, start taking them, because that's the best way to plan ahead and know that you'll be able to get the services that are being advised. All right.
Turn my video on here. I'm having a
Okay.
little problem with my
A couple
mouse.
questions for you, but I also have is this advice only for Nassau and Suffolk County applicants? No, this is a New York State discussion. So the change in the law is a New York State change, and it pertains to all of New York State. So it's not just Nassau or Suffolk. Obviously, that's where we spend most of our time, but we certainly still do stuff in the city. And it applies across the state. So definitely reach out if you have more questions about that. But Ashley, a couple of people have asked how they can get a copy of this meeting. Is that something that's being provided?
Absolutely. And good question, because I know Deanna's covered a lot today. We will email a link to the recording within a couple of days. I think another question came in. Okay. Oh, no, maybe not. All right, let me start wrapping up here. What makes Russo Law Group different? Our clients tell us that it's our dedication, accessibility, scope of legal services, and the years of experience that give them the peace of mind and confidence when working with us. We will not learn at your expense. This firm literally wrote the book on estate and elder law planning. We've helped over 17,000 families. We build a relationship with our clients. We care about you, and we want to be your attorneys for life. Having said that, here's a list of services that we provide and how we can help you and your family. I would urge anyone who has further questions to give us a call right now. We are happy to speak with you after this webinar. Finally, we appreciate all of you for joining us. Please leave your feedback in the webinar survey. Deanna and I always look forward to reading your responses right after this, so please let us know how we did. That survey will appear on your screen as soon as I end the webinar, which is happening shortly. So Deanna, thank you for your presentation. Was there anything else that we needed to address before I close this out?
No, I think we're good. And thank you all for joining us. It was a pleasure talking to you today.
All right. Thanks. See you all next time. Bye.
Bye.